Welcome back to State of CRM podcast. Today's episode, a new topic, something that we never talk about and really important and center for everyone. We are really pleased to welcome Constantin Pavléas from Pavléas Avocat. We are about to talk about all this privacy data. A lot of questions for Constantin to try to explain, to help us out there to understand the pro and cons, what's the law is telling us to do, and helping us to understand all these topics. We prepared a lot of questions for him. So Constantin, welcome. And just before jumping into the content, Matt, we have a little disclaimer because Constantin is a lawyer, so we have to do a little disclaimer on all our discussion today.
Absolutely. So I'm going to start by reading this off just to make sure I get every word correct. And this is important for people to know who are listening in, that the information in this podcast episode is provided for general information purposes only, and it may not reflect the current law in your jurisdiction. By listening to this episode, you understand that you are not entering into an attorney-client relationship. So just for informational purposes only, we're going to talk about a lot of interesting things today, but this is in no way constituting legal advice for you. So I think a good way to kick it off is we're going to be talking today a lot about data and obviously the regulations that are emerging globally around the use of data, specifically as it relates to individuals. And I think a good way maybe, Constantine, to start out would be to understand a little bit more around the different types of data that can kind of fall into this regulation or potentially out of the regulation, depending upon what we're talking about. So we have personal data, and then we have PII, or personally identifiable data. So what is the difference between those two data sets, and is that important for marketers to understand?
Yeah, so Matt, thanks for the question, and Benoit and Matt, thank you so much for inviting me today. Yeah, I think the distinction is really related to the regulations that we're talking about, and I think maybe the first thing that marketers need to have in mind is their geographical reach. So if the marketing, and I know that today marketers think global, but sometimes it can be regional. Or certain countries where they would target their marketing campaign. It's important to understand the legal, so the privacy landscape where the marketer operates. So where the marketer operates in the United States, or where he or she operates in Europe, the consequences will be, the differences in regulations will be dramatically different. In Europe, we have the GDPR. I think that by now everyone has heard about the General Data Protection Regulation of 2016, entered into application in 2018. And personal data is really a term that has been carved by European data privacy regulations and GDPR, which is really inheriting the European approach and promoting the European approach to privacy. I think the first takeaway for marketers is that personal data in Europe is a broad definition versus PII. So PII would be the way to frame the personal data in the United States, with exceptions. But PII, personal identifiable information, would relate to a defined set of data, like the name, the address, the social security number, the credit card number. You would have a defined set of personal identifiable information. In the United States. Across the Atlantic, in Europe, the definition of personal data is broad. So that's the takeaway. So broad means what? Anything that can directly or indirectly identify the person can be personal information and is subject to the European regulation. So so the IP address in certain circumstances, so the address, the IP address with which a device connects to the network can in certain circumstances be personal information. An image of you can be a personal information. Your browsing history can be a personal information. Your likes on a social network can be a personal information. Biometric data, your health data, your social security number, of course, your credit card number. So the metadata that relate to you and can identify you directly or indirectly. So there's no closed list in Europe, and I think that's really an important thing for marketers to consider.
Pretty clear. And so, yeah, that's what you're saying is that's broad in Europe. All this list, example you were mentioning, that's the case in Europe in the GDPR law, and the PII in the US is more a strict list or something more defined and finished as a list of identifier. That's correct?
Right. Yeah, that's, I think,
really interesting. I mean, maybe the next question is really, we have this understanding of the difference of the personal data, but we heard about the GDPR for sure. We also have this CCPA, California protection law. There is one in Canada too. So what are the difference between these different law regulation from different areas in the world, and especially in the sake of businesses that are operating worldwide?
Yeah.
How they need to adapt to the different laws. That's complicated. So what are the differences, and how they can really understand and do the best they can, to comply to these different laws?
Yeah, so I think we're getting to a level of specificity and expertise in this area of law where I think the general, advice would be that for compliance purposes with privacy laws in Europe, in California, in Canada, in other jurisdictions, I think that in today's world, you need legal expertise. I think, and I think that's a fair comment to make. That one wouldn't expect of a marketer to be a lawyer. However, the marketer would need to have the right the understanding of the landscape, so that they can just have that the notion and the gist of where they're going, where if what they're envisioning is something that is completely within the boundaries of the law, or something that is really challenging, so that at least they understand the landscape. But I think at the second level would really be, in my humble opinion, just go out and seek, have the validation by the experts, in this instance, the lawyers. But to answer your question, I think the way I view this, and I may be biased, right? I'm a French lawyer, so in Europe, the way I say this is that GDPR, the European regulation, is a sort of a golden standard for data privacy. And it has been like, are you GDPR grade, or are you not GDPR grade? It's interesting to see that a couple of years ago, where there was a lot of discussions about GDPR entering into application, you had Microsoft, I believe, saying our goal is to be GDPR grade everywhere, to basically have an approach in other jurisdictions that may not be as advanced in protecting privacy, to be where to raise the standard to the GDPR level. And I remember, that was a statement that was made at the time, and it was interesting from a lawyer's perspective. So GDPR is territorially broad as well, right? It covers the 27 countries in Europe, but it also has extraterritorial effect. So you're a marketer in the US, you're a marketer in China, in Russia, in outside of the European Union, and you you want to sell products or services to people in the European Union. So you would be caught by GDPR because you are targeting people to sell products or services in Europe, even though you're based in the other part of the world. You'll be caught by GDPR. If you are also profiling, you're not offering services, but you are running your algorithms to profile European people to predict behavior, analyze and predict their behavior for marketing purposes. If you're doing this, even though you're not directly offering products or services, you would also be caught by GDPR, even though you are in the United States, in California, in New York, in Boston, or in Shanghai. So that's something to keep in mind. It's not because in today's world you're based where you're based that you will not be caught by regulations from another part of the world. CCPA, the California Consumer Protection Act, is more specific in terms of, it's a regional, it's a state, these are the privacy rules that are in effect in California. They apply to for-profit organizations, like GDPR would apply to anyone processing data, to anyone, like to a non-profit organization, a business, a government, a non-government organization, anyone processing data of of people would be caught by GDPR. CCPA is more limited in scope. It's for only for-profit organizations. Without maybe getting into the details, and I'm just mindful that I would like to bore our audience here with legal details, but the rights for data subjects are different. They will be more elaborate in GDPR. I think the takeaway here is, from my perspective, that when you target people, when you market services to other parts of the world, you need to be mindful of privacy regulations in this part of the world. Even though you have no physical presence in that part, you're just running your algorithms on a server to profile people. If those people are in the EU, European Union, you are caught by GDPR, for example.
Great. And Constantin, so maybe something that's, we had a discussion preparing the episode, but that's something that we did not mention and that's coming to mind right now is that's my personal case. So I'm French citizen living in the US. If a US company is processing my data, what's happening? That's the GDPR because I'm European native, or because I'm living in the US, I'm not in the GDPR scope, and they can process my data as US resident.
It's the latter, Benoit.
Okay.
GDPR.
And just to clarify, so marketers understand that's, European citizens that are living outside of the Europe are not in the GDPR jurisdiction.
No, GDPR does not is not taking as a criterion nationality and citizenship. Yeah. It is where you're based.
Okay.
However, if assuming Matt, you're not a European citizen, I don't know, but assuming you're not, assuming you're a US citizen and you travel to Europe and you stay in Europe for a certain period of time, you'll be, GDPR would apply to you and you'll have rights under GDPR. But not French citizen being in the United States and living there, GDPR doesn't not apply to you.
Super clear. That's really interesting to specify, to clarify. That's really interesting. Maybe I have maybe one or two follow-up questions on this topic, and we can highlight that there is a difference between CCPA and GDPR in terms of age of consent. There is a difference here, and there is another one that I feel that it's interesting to highlight too, is that what is the risk? What are the fines that what is the money if you don't you have to pay if you don't respect the law? And again, the difference between the two, the Californian law and GDPR, there are differences there. So maybe first on the age, there is difference in my understanding is correct between there is one for 16. The consent is at 16 years old and the other one at 13. Can you just give a little bit more detail on that?
That's right, Benoit. The age of consent, the age of the adult consent under GDPR is 16 years of age, and in the California Consumer Protection Act is 13 years of age. So you have differences. They're very material because there are a specific set of rules for protecting children in privacy laws, GDPR, CCPA. So addressing the market for children, this is an enormous business, of course, but there's rules that are even more protective. And I think as citizen, we can understand that. But yeah, that's really a very material point to make. You're right.
And yeah, I mean, having a kids in this area of age, that's something that's related to me and saying that's mean when he's using his smartphone, what's the protection of his data on the internet? Great. And so the fines. I mean, what's the law is saying that if you don't respect and you are not respecting these laws, what can be the fine, the penalty for the company, for the business?
Yeah, and they're actually very material. I mean, it's not. It's complying with privacy laws has really become a something that is subject to fines that are so significant that I think compliance has reached in many organizations the C-level people because the fines are so important. It used to be, if we take some history, let's say in France, before GDPR and before certain laws, let's say about 5 to 7 years ago, the maximum fine was 150,000 euros. Now, for an SME, a small medium enterprise, it was probably significant. But for many companies, global tech companies, those amounts were completely negligible. In today's world, under GDPR, fines can be the higher of 2% of worldwide turnover of the group, 2% or 10 million euro for the lower category of breaches. And for the higher category of breaches, it's 4% of global annual turnover, or 20 million euros, whichever is higher. So those amounts, I mean, for an international group of companies, 4% of annual turnover is significant.
That's huge. That's huge.
Yeah, it can really drive your share down, even being under scrutiny by the supervisory authorities in terms of, so you have the fines and you have the loss of goodwill and reputation and all that comes along. So it's super significant in today's world. CCPA has a different approach. It's not absolute amounts in terms of global amount or a percentage of turnover. Is a number of thousands of dollars per file, per data privacy file. And depending on the number of files that are included in the scrutiny for breach of the CCPA, it can amount to incredible numbers as well. So I think the takeaway here for marketers is that this is really, this is not a playground, let's say. It has an impact, and it really has a consequence.
Yeah, serious impact, definitely. That's huge. And as you mentioned, I was making the calculation, saying that we are talking about thousands of dollars per record. But usually when you are a global big brand company, you have millions of customers on your database. And if the breach, the issue is on like even a portion of it, and you have an issue on 100,000 people times 2,000-3,000 per record of fine. I mean, you are ending up paying millions or dozens of millions of fine. And that's just, you can't just, as you said that in the past, say that, okay, that's not important, and that can even be anticipated as a marketing budget, and we don't want to respect the law. I mean, that's no longer the case, and everyone is aware about it for sure. The point is not to say that, hey, wake up, that there is something coming new, but that's really important, and that's why marketers really need to be aware about this kind of potential issue and impacts on the global company if they are not careful with their practices.
That's right, Benoit. And maybe just to give our audience, the figure is under CCPA, $2,500 per record for each unintentional violation, and $7,500 per record for each intentional violation. So it really can reach the sky there.
What's the difference between intentional and unintentional? Like, what does the law mean by that?
Yeah, so in general terms, right, I'm not specifically talking about CCPA, not being a California lawyer, but an intentional breach would be, for example, you very well know that you do not have the right to sell the data because the consumer in California, for example, has opted out from the right for the marketer to, or for the possibility of the marketer to sell on the data. And despite that opt-out, that clear opt-out, the company has sold on the data. That would be intentional. You knew and you didn't care. I mean, you basically, you've overridden a clear prohibition. You've done it intentionally.
Yep.
Unintentional would be you have been very negligent in the way you have secured the data. You haven't, let's say that this may not be the perfect example under CCPA. There are not specific security rules in CCPA as far as I know, but under GDPR, for example, an unintentional breach would be you have not put together sufficient security measures to protect the data, although it's and actually GDPR doesn't really make the distinction between intentional or unintentional. It's really very strict liability. Have you complied? Yes, no. Whereas in the United States, you have that distinction, intentional, unintentional, which probably plays in favor of the business, because of the processor of the data, because most of the time one may think that the violations are unintentional.
Yeah, that makes sense. And you were talking a little bit about opting out. And kind of giving consumers a little bit of control over how their data is used. And I know there's some differences between the laws themselves in terms of like how that actually impacts what a company can and can't do. But I think if I'm not mistaken, GDPR is very much focused on sort of this idea of opting in and out. And I'd like to get an understanding potentially around what does that really mean from a consumer perspective? Like, what tools does that give a consumer to either control the use of their data or limit it in terms of what companies are able to do? And are there things marketers, especially that are transacting internationally, should know about the differences between the laws and what that means for consent?
Yeah, well, that's really for marketers, that's a key question. But it's awfully complex to the extent that in Europe you have GDPR, but you also have other regulations like the e-privacy directive, and the European legislator is putting together a new set of rules for e-privacy. What does that all mean? If we just go back to the principles, with a GDPR focus at first, GDPR says in order to process data, you need to have a legal basis. And a marketer would think, well, the legal basis would be consent. So I need to go out and get consent. I need opt-in or opt-out. That would be, I think, the first thing that we would all think about. What is the legal basis? Has the person agreed? Have they consented? But GDPR goes beyond. GDPR would say you have the right to process data, you have legal basis if you have consent, consent being the sort of the cornerstone, right? It's a foundational legal basis. But you have other legal bases. You have the necessity to perform a contract. I'm entering into a contract online to get whatever, this book, and the platform requires my name, my the mail address, the physical address, the phone number, my credit card number, all those data. I don't really need to consent to give them because these are required for another purpose, which is the performance of the contract I'm entering into. And there is this notion under GDPR that those data that are collected and processed for a particular purpose, the controller, so the person who processes the data, they can only process them for this purpose or a compatible purpose. Now, if the controller gets those data to send me the book, and they combine those data with another data set of my browsing through, a certain number of websites and my likes on the social media and my geolocalization and this or that for different apps, and they profile me as a person who likes this book, would like this other book and this other thing and this other thing, and frame me in a political, in a social political profile, they would need to get my consent, or they would need to get some other legal basis than just performance of the contract, because they do not need all this information and they do all this processing that has nothing to do with selling me the book. So for, I think, marketers, the takeaway is there is more than consent as a legal basis for processing data. There can be performance of contract. There can be legitimate interests. I, as a marketer, have a legitimate interest in doing business, to promote my products. So I do not need to go for opt-in in order to provide information to the data subject, to the person in the European Union. I have the legitimate interest. However, the person can object, may say, you know what, I don't want I don't basically want to have that targeted advertisement whenever I go online to do this or that. I don't care. I would opt out. So legitimate interests, I'm opting out. So there is this, and this is why I said this is a complex matter, because you have different rules kicking in. You may have consent, you may have legitimate interests, you may have performance of contract, you may have other legal bases, and all these are caused in relation to the purpose, to the actual process and the purpose for which you're doing the processing from the marketer's side. So there, in certain cases, you may have opt-outs. In certain cases, you may overrule the opt-out when you're a marketer. You may say, what's really wrong about me sending you, targeting you online? Am I really overreaching and bothering you? And the other person may say, the data subject may say, well, you have profiled me. If you profile me, I can opt out. These are the European rules. So that's complicated, but the takeaway, I guess, is in certain cases you may have to go for opt-in. In certain cases, and you would need your legal expertise here to minutely give you, direction. In certain cases, opt-out is okay. In certain cases, you can override the opt-out. In other cases, you can't. But I think the way you design it, and that's interesting. I think this is where the legal, the privacy lawyers and the business lawyers would really be partners to marketers, if we take it from that angle, is that with this expertise, you can help the marketer design the campaign, design the marketing offer in a way which is, serves the purposes of the marketer, but also is compliant with the privacy regulations.
So Mats, that's a lot of information so far. We have more questions coming next, but for now, maybe let's stop here for today. That's the end of part 1. We'll do a part 2 and share that with you guys in the audience. We have, again, more questions for Constantin, and we'll see you in a week for the part 2.
Sounds good.